All right, we will start the webinar now. Thank you everyone for joining us at today's webinar on litigation. My name is Samira Amari. I'm the head of business development and marketing at Afridi and Angel. Our speakers today are partners Chatura, Randeniya, and Mevan Bandara. Before I hand over to Chatura and Mevan, I want to remind you to submit your questions in the Q&A throughout the webinar. We will run through the presentation first and then do a discussion after at the end. And we will try to address all the questions that come up and anything that remains unaddressed, we will deal with offline post-webinar. The webinar is scheduled for 45 minutes. And it is recorded, and the recording will be posted on our website next week and shared with all of you. Thank you again for joining us, and over to you, Chat.
Thanks, Samara. Good evening, everybody. Thanks for being here. Hopefully, we'll make this fairly productive use of your next 45 minutes. One of the notable features about the legal system of the UAE, if not a unique one, is that it gives you several fora in which to resolve your disputes. In addition to the onshore courts, you have the DIFC courts, which you can opt into. You have the ADGM courts you can opt into. And of course, you can agree to arbitration. Now, it's fairly common knowledge that the DIFC courts, the ADGM courts, and arbitration has grown a lot over the last couple of years. And that growth is fueled primarily by the weaknesses, which might be actual or perceived, of the local courts to handle certain types of disputes. So you may find yourself in the onshore courts trying to resolve a dispute for a number of reasons. The first could be that it is a dispute which you can't really arbitrate or go to the DIFC courts, for example, a labor dispute. It could be, and this is far more common, that at the time of contracting, you did not agree to an alternative forum, and therefore, by default, you have subjected yourself to the jurisdiction of the onshore courts in one of the 7 emirates. And the last is obviously that you may have an arbitration clause or an opt-in clause in your contract, but for some reason they're faulty, and therefore again you are back in the onshore courts. Now, in a dispute resolution system, there are 2 outcomes, 2 things that really matter to parties. One is having a good outcome, the quality of the outcome. And the second is the speed with which that outcome is reached. So good results fast is essentially what people are looking for when they want to utilize the system. And one of the things that we will be doing over the next half an hour or so is to look at, if at all, and if so, how much the needle has moved towards the onshore courts, thanks to these amendments that have been made. Now, the 2022 law, which came into effect in January of this year, replaces a law that was passed in 1992. It might be easy to think, oh, my goodness, it's a new law after 30 years. A lot may have changed. That's not necessarily the case. Over the last 5 or 6 years, there have been regular changes to the Civil Procedure Code or the Civil Procedure Law, and a lot of them have taken the focus towards making litigation faster and more efficient. Perhaps one thing that's noticeable to the law here, the recent amendment to the laws, which is both to the Civil Procedure Code and the Evidence Law, also passed in 1992 for the first time, is that it also focuses a little bit, or a fair degree, on the qualitative nature of the proceedings, and therefore, hopefully, will result in better outcomes. So on your screen, you will see a brief overview of what we will be going through. But just to set the stage, let's discuss the nature of the beast. Litigation before the onshore courts. So it's a civil law jurisdiction. There's no concept of a binding precedent as you will find in a common law jurisdiction. Now, it's not an absolute. Over the last couple of years, we've seen a move by the legislature to recognize what they call judicial principles. It's a rather ambiguous concept, but essentially, if there is an established line of decisions that have been given by the higher courts of the land, then that would have an effect which is more than persuasive evidence. The proceedings are obviously in Arabic. There is very limited, or there was, may I say, very limited oral advocacy. So everything is done on the basis of written documents, and the courts place a lot of reliance on experts. Any matter that may have even a slightly technical nature, or even requires a computation of damages, is very likely to go to an expert. Only UAE nationals can appear in the onshore courts. This is as of December 2022, and actual legal costs are not recoverable. Regardless of the outcome, even if you win, you'll only get a couple of thousand dirhams as your costs, which is to be contrasted with what is the position in, say, the DIFC courts and arbitration. So we'll be looking at 3 new laws this afternoon. The first one is the civil procedure law. The second is the evidence. And thirdly, to a much lesser extent, is the advocacy and legal consultancy law. Albert, can we move on to the next slide? So what are the major changes? The first is the introduction of English language courts. As Mevan will get into that, we'll get into that a little later on. How service of summons is to be effected on parties, the introduction of certain specialized courts, changes to the way in which proceedings are conducted in the onshore courts, changes that have been made to the appeals process, and finally, a topic that is of perhaps heightened interest to commercial parties is a new treatment of payment orders, which are now called a writ of debt. Could we move on? Thanks. So the first thing, and this is perhaps the change that really caught the public imagination when this law first came out, is the introduction of English language courts. Now, to be clear, they have not yet been set up. What the Civil Procedure Code does is to say that certain entities or certain judicial authorities, so if it's within the federal court structure, it is a chairman of the Federal National Council, or if it's, say, a court system that exists outside the federal system, for example, Ras Al Khaimah or Dubai, the head of the local judicial body now are empowered to create a circuit which would function in the English language. And it's not a court of general jurisdiction. When they are set up, they will be set up to look at certain specialized cases or specific cases. There's still no guidance as to what these might be. But for example, it could be something, for example, in the construction sphere or international trade, for example. So all statements and pleadings will be done in the English language. And what is also quite important is that this also means that you can submit evidence in English. Right now in the onshore courts, all written evidence that you are relying on must be translated into Arabic by translators certified by the Ministry of Justice. And depending on the nature of the case, that could be a fairly heavy outlay. And because those costs are also not recoverable. Now, to complement this development, the advocacy law and the legal consultancy law now has permitted foreign lawyers to appear before the onshore courts, but they are subject to certain requirements. Could we move on? So the framework has been set up, the idea has been sort of planted in the law, but there are still a few questions that remain unanswered. For the first, and perhaps the most important one, who will be the judges? Will it be a foreign judge? Obviously, the judge will need to be conversant in English. The The other is obviously, and this is what's going to be really interesting, is what kind of cases will these new courts hear? Can the parties agree that the language of dispute proceedings will be English? Yes, the English language is always there. And why that this is important, and we'll get into this later on, is now the parties can agree on specific rules of evidence. That's there in the evidence of law. In the evidence law, the litigants can agree on specific rules of evidence in writing, so long as it is not contrary to public policy. As when we look into the evidence law, we'll discuss what these changes might be. For example, the rules regarding document production, creating a duty of disclosure to the court. Right now, well, as of December last year, that none of that existed. So there are a few questions to be answered, but generally speaking, it tries to redress one of the major concerns that users had of the onshore courts, which is they didn't understand what was going on. It's important for parties to know what's going on, and that's why that's a key reason why arbitration and the DIFC courts and so on have been quite popular. The next slide, please. Mevan, will you take over from here?
Yeah, thank you, Chatura. So with regard to the service of summons, there are two main changes that have occurred with the introduction of the Civil Procedure Code. And before I get into that, it's worth to note a few distinctions. The UAE courts still undertake the service of summons, unlike, for example, in the DIFC court, where summons need to be served by the parties themselves. However, if a party wishes to serve the summons directly, not through the court process, that is possible by getting the permission of court to serve the summons. In 2019 also, electronic means of service was introduced, first as an alternative mechanism, but now they've maintained it as something that can be done as a first option. So these electronic means would include email, WhatsApp messages, even video calls or voice calls. One of the main changes that have been introduced in the new CPC is that they've somewhat agreed that the parties or recognize that the parties can agree to the method of service or the place of service. So this is, in my view, a bit of a significant development, because that allows the parties to pre-agree the method of service in the event of a dispute, and also where summons can be served. And that information is information that can be submitted to the case management office, where approval will need to be sought as to where summons have to be served and the method of service. Another new development is with regard to the service of summons outside the UAE. Previously, what happened was that you had to send the summons through diplomatic channels and wait for confirmation that summons have been served overseas. This used to be a lengthy process. Sometimes we've seen instances where a couple of months are taken for confirmation that summons have been served. This has changed, and somewhat of a cutoff date has been included into the law. And that is that the courts will consider service being satisfied within 21 days from the date the diplomatic mission in the UAE receives a summons from the UAE Ministry of Foreign Affairs. So this gives you a 3-week window for the party outside the UAE to come into court prior to the court taking various steps to continue with the case without the defendant being present. So those are the main changes as far as the service of summons are concerned. Can we go to the next slide, please? Another aspect which has been introduced in the new CPC is the specialized courts. As a background, the UAE did not have specialized courts. what was there was basically one set of judges listening to all the matters regardless of what the area was. So you'd have, for example, a commercial judge looking at a civil claim, or a debt claim, also looking at a maritime claim. But certain amendments to the CPC, specifically Article 29, makes it apparent that the law is really moving towards having specialized courts. This can be seen from a few aspects. One is the fact that now only one judge benches will be set up in the court of first instance. Previously, 3 judges had to be constituted in the court of first instance, but Article 29 specifically states that only one judge will be there. And this would, the consequence of this is likely to mean that there will be a lot more divisions in court where there'll be more judges available to hear matters. The CPC also talks about small claims matters, and that's divided into 2 broad categories. One are claims which are less than 50,000 dirhams. And in such case, the law provides that it would be determined by the court of first instance and that there will be no appeal that is available. The second category of cases deals with matters which are over 50,000 dirhams but do not exceed 1 million. And they're called the single hearing cases, where the court is required to determine the matter within 1 hearing date. Also included within this category is any dispute relating to the authentication of a signature. So just to put it into perspective, what happens is that first, all your pleadings are filed before the case management office. Thereafter, the matter is referred to a judge who makes a decision. So the period in which a claim is kept before the case management office has also been specified for these small claims matters and the single hearing matters. And that is that the first hearing, which is the hearing where the judge is supposed to be determining the substantive issues, must be scheduled within 15 days from the date of the statement of claim being filed. And this 15-day period can be extended by a further 15-day period, which would mean that your case should be heard within a period of 30 days at the most, if it falls within these small claims categories. So, a point to note there is that you're likely going to have very little time to submit your defense, and very strict timelines that need to be adhered to. Can we go to the next slide? Chatura?
Yeah, so for me, these are perhaps this is the meat of the changes, is how the CPC and the evidence law really affect how proceedings will be conducted. So a couple of changes are particularly notable. The first is that now the parties have the freedom within their contract to agree what rules of evidence will be applicable. So it does not necessarily have to be the federal law on evidence. So long, the only caveat is that it can't be contrary to public policy. It's a little difficult to see how a rule of evidence could be contrary to public policy, except to perhaps to the extent the conclusive nature of official documents being disregarded. So for example, parties can agree to use something like the IBA rules of evidence, although it is quite common in use in arbitrations in the UAE. They may adapt that, for example, for use in litigation. There are fairly stringent requirements to submit all your evidence and your written pleadings in the case management office fairly early. So which means that you really need to put in your full case as quickly as possible. And there could be instances of fines being levied on parties which fail to do so. The next 2 things I think are perhaps the most important. The first is that at least a greater role for oral advocacy is now included in the law. There are specific provisions regarding who will speak first, what might be addressed, the order in which rebuttals may be made, and so on. This is quite a departure from a tradition which is usually, which has always been very written submission oriented. Another key change is now you can actually ask your opponent to disclose documents. There's no such requirement prior to this law coming into effect. And how the system used to tackle this kind of issue was by appointing an expert to go and look at the documents, to visit the offices of the parties and look at the documents, but that did not create a positive obligation on any of the parties to produce their documents. Now, a party, whether it's a plaintiff or a defendant, can make a fairly pointed, very focused request to the other side to produce any documents that they might think is relevant for their case. They must be the documents. It can't be what we call a fishing expedition. The documents must be identified clearly, either as individual documents or as a category. The documents must relate to the underlying transaction. So in other words, the document must be relevant. It can't be used as a method to infringe on trade secrets. So essentially, there's a defense to a request saying, look, this is confidential information, we can't give it. And importantly, a court can draw an adverse inference if a party refuses to produce documents. In other words, these documents exist, you refuse to do it, so there must be something in there that is not going to be favorable to you, and we draw that adverse inference. Could we get the next slide, please? Of course, now you have, like I referred to earlier, you actually have detailed provisions on bringing witnesses in. Again, prior to this law coming in, the way witnesses were handled were largely by the experts. And this is a simplistic exercise of an expert going to an office and talking to the relevant people, or asking the relevant people to come and talk to him. But that was really a process that was controlled by the expert. There was no guidelines, there was no rules. You couldn't really cross-examine or put questions across unless you had a particularly good expert who would ask you whether you have any questions, so that the expert can put it to the witnesses. And of course, all of this took place out of court. Now there is provision made to present witness evidence in court, which is great, because not everything can be captured by documentary evidence. There's a lot that can be added to a case through oral testimony, and the new evidence law actually makes provision for it. There's an ability to subpoena a witness, essentially to get somebody to compel them to give oral evidence. And the law also contains provisions on how you may cross-examine. It says you can question the credibility of the witness, but there are certain parameters as how that can be done, how the questions may be asked, how the cross-examination may take place, how the re-examination may take place, and so on. Now, all this is well and good. What really matters is how this is going to be implemented, because at the end of the day, if this all looks very familiar to a common law trained lawyer or a judge, but it may not necessarily be the case that a civil law judge or a lawyer will be equally familiar with these concepts. So it's going to be quite interesting to see how the judges in particular will apply this. There is provision made regarding court-appointed experts. Now, parties can agree who the expert is. The courts routinely used to allow this as a matter of practice, to say, look, the parties can agree on the experts. If they don't agree, we'll appoint somebody from the role of the experts, but now it's clearly set out in the law. Very importantly, now you can have international consultancy firms which can be permitted to act as experts. Of course, the limiting factor is going to be the Arabic language, unless you're going to fall within the one of the newly created English language circuit courts. You'll still be conducting the proceedings in Arabic, so they will need to be proficient in the language. Could we get the next slide, please? I think Mevan, back to you.
Yeah, thanks. So on appeals, the standard advice generally that we give is that appeals are available as a matter of right in the UAE. There's no real leave to appeal stage as such. And that's resulted in a lot of appeals being filed just for the sake of an appeal being filed, particularly because there's no cost consequence. Certain amendments have been made on that, but in essence, we would say that the right to appeal, whether it be to the Court of Appeal or the Court of Cassation, still remains as a matter of right. As far as timeline goes, an appeal to the Court of Appeal has to be made still within a period of 30 days. With regard to the Court of Cassation, however, which previously had a time limit of 60 days from the date the Court of Appeal judgment was issued, has been reduced to 30 days. So now an appeal to both the Court of Appeal and the Court of Cassation would need to be filed within 30 days of the judgment being rendered. With regard to the Court of Appeal, an appeal is still available as a matter of right. However, the judge assigned to hear the appeal can determine the appeal in chambers within a period of 20 working days from the date the case is referred to him. The judge will essentially have to determine whether a further hearing date would be required where the matters would be looked into, or he can determine whether it's going to be the appeal is going to be allowed or dismissed. Reasons need to be given by the judge, regardless of whether that determination is made within the 20-day working period in chambers, or if there is somewhat a retrial. Here for practitioners, as well as people engaged in litigation, a point to consider and note is that this would mean that the submissions that are filed before the case management office needs to be as comprehensive as possible, because you might not get another opportunity to file a further submission once the matter is referred to court, to the judge, because the judge may determine this issue in chambers within that 20-day working day window. With regard to appeals to the Court of Cassation, that is still available as a matter of right, provided that the claim relates to has a monetary threshold of a minimum of 500,000 dirhams. And appeals to the Court of Cassation are only limited to matters of law, issues of law that are concerned. Can we have the next slide? Finally, we're going to talk about the payment order. Payment order was introduced somewhere around in 2019, and the purpose of this was to have somewhat of a summary process if the debt was confirmed. The new CPC has somewhat rebranded this concept, and instead of calling them payment orders, it's been called a writ of debt. The requirements, however, still remain somewhat the same. That is that the creditor's right needs to be well established in writing. The sum must be due for settlement, whatever is outstanding, and your claim has to be limited to a debt of money of a specific amount. So it needs to be a specific amount identified in order for you to get a writ of debt or a payment order, as it was previously called. The process is somewhat as similar as it was before. A demand needs to be made, and the demand needs to specify that payment needs to be made within 5 days. If no payment is made, then a petition can be filed, setting out your claim. The petition is heard ex parte, and the law provides that the decision must be rendered within 3 working days. In our experience, the 3 working day period is not always adhered to, but it's much faster than the ordinary process. And if the writ of debt is given, the writ of debt must be served on the debtor within 3 months. If it is not served on the debtor within 3 months, the writ of debt becomes null and void. And An appeal is also possible from a writ of debt, and that would be within a 15-day period from being served, from the writ of debt being served on the debtor. Chatura?
Thank you. So that really concludes a fairly whirlwind tour of the changes that have been introduced. So you go back to the question, how far does this move the needle? I think the answer to that, at least in our view, is that it's an improvement, certainly several steps in the right direction, but perhaps not sufficient to sort of make a significant change when a party is considering which forum is the most appropriate for them to resolve their dispute. I think there will be a teething period for these changes. Like I said, some of these concepts are fairly new to the UAE legal system. The judges may not be very familiar with some of these concepts, as well as certain advocates. So a lot needs to be sort of, for a lot of issues, there needs to be a wait and see kind of approach, especially with things like document disclosure requests, with cross-examination of witnesses, and oral advocacy. But certainly it's a step in the right direction. And for some reason, you are subject to the jurisdiction of the onshore courts, whether it's by default, whether it's by oversight, whether it's by a faulty dispute resolution clause. I think your position is going to be somewhat better than it was a couple of months ago. Perhaps we can take a couple of questions. Please do free to type them in as we go along. One of the questions that we get asked fairly frequently is about experts, and experts tend to be a major sticking point when it comes to onshore court proceedings. And the reason is that the court really relies on expert reports to perhaps some might say an unreasonable degree. Part of that is that under the law, if the court agrees with an expert, it can simply say that it agrees with the expert. But if it does not agree, then the court actually has to articulate the reasons why it disagrees. So it may be a case of the path of least resistance for certain for cases. And quality of control of the experts is always an issue. If you can't agree on the expert, it will be assigned to an expert at random. And we've had difficulty in the past with certain experts in terms of quite frankly competence in certain cases, honesty in others. Now, the new experts law does try to put in certain standards. It has been a criminal offense for experts to act in a partial manner for quite a number of years now. But the problem is that it's a fairly difficult threshold. It's very difficult to prove that the expert was biased or was corrupt or had otherwise misunderstood what the true nature of the dispute. So that remains an issue, and I think there's a recent set of guidelines that have been issued as far as experts' disciplinary proceedings are concerned. Again, we'll have to see how they're implemented before we can sort of see whether that will lead to a difference in the qualitative nature of experts' reports and how the court relies on them. Do we have any other questions? There's a question here. Whether the English language courts will cover criminal proceedings? No, it will not. This is there's a new criminal procedure code also that came out, which made no reference to to English language courts. So at least for the time being, this seems like an innovation that's going to be limited to the civil courts.
There's another question. Yeah.
Yeah. Whether you have a payment dispute with a party in Oman, can you file a case against a party in the UAE? So there are a number of grounds under which you can invoke the jurisdiction of a UAE court. One of them is where the debtor or the defendant resides. So if the defendant is resident in the UAE, you can obviously file there. That's not the only grounds, though. There are a couple of other things. For example, if it arises out of a contract that was executed in the UAE or was performed or executed or performed or was otherwise connected to the UAE, you can. So the short answer is, if the contract has a nexus to the UAE, in theory, you may be able to. The facts of the matter require further investigation. The question is whether even if you could, whether it's advisable to, because you will need to, even if you get a judgment in your favor, then you'll need to take that judgment across to Oman and enforce it there. So you'll be going to the court system there again. So rather than duplicate proceedings, there might be actually a case to be made out that even though under law you can start a case here, you may be better off pursuing them directly in Oman.
Okay, I think we could probably wrap up, and I just want to let everyone know that we will share the slides with you. A couple of people have raised that question. Yes, we will share the slides, and as I mentioned earlier, the recording will be on our website, and it will also be shared with you directly. And if you have any other questions that between now and actually there's another question that just came in. What about filing fees? Do they have DIFF if trial in English version?
I think that's different. No,
Yeah.
that hasn't been. I mean, that may well be the case. It's not provided for in the law yet, so it will normally go. We can only assume for the time being, and until something contrary is put out, that it will be under the same court fee structure, which is in Dubai, for example, 6% of the claim value with a cap, with a ceiling of 40,000. But that's something that could very well be regulated by the courts or the legislators later on. And that is something that is likely to be addressed at the emirate level rather than at the federal level.
Do you want to take any more questions?
Okay, there's another one.
Yeah.
So if an entity is registered in the DIFC and wants to file a case against an entity onshore, can the matter be heard in the DIFC courts? Mevan, you want to take this?
Yeah, sure. It would depend on whether, well, the simple answer probably would be yes, but it would also depend on whether the contract was executed or performed in any form within the DIFC limit. And if the answer to that is yes, then the DIFC courts are likely to have jurisdiction. But if there's no connection whatsoever with the DIFC and the defendant is outside the DIFC, then that might be a different kettle of fish.
Okay. Well, thank you everyone for joining. Thank you, Chatura. Thank you, Mevan. If there are any questions that anyone has, feel free to contact Chatura or Mevan directly. And looking forward to having you on other webinars this week and in the future. Thank you very much.
Thank you.
Thank you.